Can we start? Welcome to the webinar Ensuring Data Subject Access Request Compliance, Navigating Requests and Building Customer Trust. GRCI Law team is delighted to welcome you here and share with you the experience we have in this field. My role here will be to introduce the team that is participating to the webinar and also give you some overview on the group and also the data subject access request services. So my name is Loredana Tassone. I'm acting as the managing consultant and head of EU and UK representative services here at GRCI Law. I have joined the group on 2018. Previous to joining GRCI Law and the group, I have been working in international law firms. So I'm a qualified lawyer specialized in privacy and cybersecurity. I have been working at the Registry of the European Court of Human Rights and the Council of Europe, and also completed a PhD thesis in the European and International Law Department with a thesis on data privacy and cybersecurity, and I also fulfilled some role as a lecturer in several universities such as Manchester, Salford, and Strasbourg. I am delighted to introduce John Pott, who is a very experienced DPO consultant and data subject access request expert, and has been supporting in breach and incident many clients over the years. He is a consultant for GRCI International Group and has extensive knowledge in managing data subject access requests, and has also covered important role in central government, such as DPO or Department of Security Officer, and has also previously served as head of information law and security at the Metropolitan Police. I would also like to welcome Ellen, equally highly qualified in the field. She is the Incident and Breach Management and Data Subject Right Consultant here at GRCI Law. She has a lot of experience on handling complex data subject access requests and also managing incident and data breach. She has a very good experience in consumer and criminal law and dispute resolution, and she has also worked for trading standards and construction trade body as an in-house DPO. So she's the one well placed to provide advice and guidance to clients on data protection compliance, as well as implementing data protection policies and procedures, including delivering of staff trainings. As for where we sit as a team, so we are in GRCI Law. GRCI Law is a legal risk and compliance consultancy firm. It is composed of experienced DPO, lawyers, and barristers, and we are not a traditional law firm in the sense that we are not under the regulatory body, and we do not do contentious activities. So we help basically the companies to reinforce and maintain their compliance so that they can avoid disputes. So we will intervene prior to that stage. And so we offer a set of the privacy consultancy services together with ITG Governance, which is our sister company within the GRCI International Group. And so as for the services we offer within GRCI Law, you will have data privacy manager services, in addition to, of course, the data subject access rights service, the DPO services, and data breach management services. In ITG, you will have services related to offer of software that help to implement compliance and facilitate the task to reach compliance, or at least a good level of compliance, books, and also support for implementing the standards of legislation, also offer of learning and staff awareness, cybersecurity services, and privacy services. In the following slides, so here we see our expertise, your peace of mind. So we have been chosen by a number of clients. You see here some impressive figures. So more than 1,300 projects have been completed to help organizations to prepare and maintain their ISO certification. More than 50,000 privacy and cybersecurity training have been delivered, and we have issued more than 7,000 Cyber Essential certification, and more than 2,350 customers use the governance, risk, and compliance software. Before we go to the substance of this webinar, I would like to make some reminders in terms of housekeeping. So all the participants will be muted during this session. However, you will have the possibility to submit your questions. You will find on the top right of your screen facilities questions. So you can write there your questions. If we do not have time constraint at the end, we will deal with all of them. If not, we will deal with some, and therefore, for those that we do not manage to cover, you will be contacted separately by email and you will obtain the clarification you have asked for. And do not bother of taking any notes, as we will gonna, of course, send you a copy of this presentation and also the recording. Without other ado, I give the floor to John Potts, that will kindly share with us his experience on data subject access request.
Thanks, Loredana. There's quite a build-up. Let's hope I can live up to it. Okay, today's agenda then. The agenda that we're going to cover today, introduction to DSARs, the challenges faced by organisations when handling DSARs, how to simplify the processing of DSARs, which is something that we obviously all want to get our heads around, and the practical steps to manage DSARs in compliance with the GDPR. I'm going to talk about the GDPR, but obviously I'm talking UK GDPR, so as long as we know where we're talking about across the board there. Okay, so an introduction to DSARs then. Let's get straight in with the basics. Oh, excuse me, I'm sorry. Start with the basics. We should remember, of course, that not everybody's been dealing with DSARs since the beginning of the GDPR. Lots of organisations coming into it, or they've just started to impact on DSARs. And although we are 6 years down the line in GDPR, I can tell you that as recently as last month, I received a letter from an NHS organisation, i.e. a hospital, that told me that I had rights under the 1998 Act, and that if I didn't tick the box, I would be automatically entered for clinical trials. So there you go. Here we are, 6 years down the line. So there's still people that not quite got their head around DSARs and GDPR. So some basics. It's basically a request made by or on behalf of an individual for the information which he or she is entitled to. It sounds simple. Remember, the application there can be verbal or in writing. It doesn't have to be an email. It doesn't have to be in a set format. Remember that DSARs are not just from clients and customers. As we'll see later on, there's been a massive increase still in internal DSARs from staff, disgruntled staff, ex-employees, etc. And of course, we've got the third-party applications. Normally, third-party tends to be law firms of that ilk, but of course, it can be parents or guardians, etc. That submit the DSAR on behalf of somebody else. And again, we'll talk about verification of identification at a later stage, but these are the basics that we need to get our head around on there. Just a quick one about when the clock starts on here, because it's something that's really important. Everybody needs to be able to recognize a DSAR. So let's think about that as we go forward as well. Okay, so the right of access then. Points to note here is that it's a copy of their personal data. It's not anybody else's, it's their personal data. It's confirmation that their personal data is being processed, and confirmation of how and why their personal data is being processed and the lawful reasons for that processing. Now, the thing about this is that, of course, we can answer the majority or second and third part of that question by using our privacy notice. Sorry, certainly the third part of how we're processing data. Okay. So what do we as data controllers need to know? We need to know that the information must be provided within 1 month of receipt of a request. This was something that GDPR and the ISO couldn't get their head around to begin with. as to when does that month actually start. It starts on the day you receive the request. Simple as that, and it's 1 calendar month. Can be extended by up to 2 months for complex or numerous requests if you inform the individual within 1 month with reasons for the extension. It's really important that we get our head around the fact that extension, the reason for the extension, has to go out within the first month. You can't decide after 6 weeks or whatever that you're going to apply an extension. Requests can be refused. Don't have to answer every one, but where requests are manifestly unfounded or excessive or particularly repetitive, we can refuse them under certain circumstances. Bearing in mind that the controller has the burden of demonstrating the correctness of that decision. And this is something that the ICO will come down on quite heavily. The ICO needs to know your rationale and your thinking as to why you think it's manifestly unfounded or excessive. Controllers should verify identity of the data subject, particularly in relation to online identifiers. The point that I would say here is that we sometimes get over ourselves and get ahead of ourselves and submit an acknowledgement, send an acknowledgement out to the client to say, look, we've received your DSAR and all the data that we hold on you will be forwarded as soon as possible. If we do that before we've verified the identity, we could almost be in breach. In fact, we are breaching the act at that stage because we've not verified the identity, but we are confirming that we hold personal data about that person. So just think about when you send your acknowledgement letter as to whether you've received the data, that you've verified the identity of the person. Thank you, Trudy. Okay, failure to comply with the DSAR then. The ICO has stated that between April 22 and March 23, over 15,000 complaints regarding DSARs were lodged with the ICO. It's the biggest amount of, or it's the most amount of complaints they receive. And this, of course, I suspect is in ratio to the amount of DSAR submitted. And it tends to be timeliness. Thanks, Trudy. So this is the quote from the ICO. Many of these complaints were driven by misunderstanding or delays by companies in responding to these requests, often from employees failing to meet the strict timelines or not recognizing informal DSAR submissions, which can even be made through social media. This is where it's important that we are monitoring all of our social media platforms for the DSAR that's going to slip in there. It's also important, and whenever we do a gap analysis for an organization, a company or a charity or any organization, if we're on site, one of the questions that we'll ask at reception is, what if? What if a member of the public or a former employee comes in, client, a customer or whatever, and asks for their personal data? Do they know what to do? And that's the important point that the ISO is getting across, that people need to know how to deal with a DSAR and how to recognize it. Okay. Okay, thanks, Rudy. Okay, so the challenges facing with a DSAR then. The vast amount of data held by organizations now. We're all aware that we collect information, it comes in from all sorts of places. The subjective nature of many disclosure exemptions. So what is it that we want to exempt? What is the data that we're holding? DSARs are expensive, time consuming and hard work. We know that. Many organizations lack an effective process. This can be encapsulated really with the 6 Ps. Prior preparation and planning prevents poor performance. It's an old adage, but one that fits. And those of you that know me previously from a previous life will know how mature I've become in putting those 7 Ps together. I'll leave that one with you for those that know me. Okay, so how can we simplify the process? Thanks, Rudy. Sorry, we've jumped a slide. Okay, the challenge of dealing with a DSAR then, 90 organisations 90 organisations surveyed in April 24, 71% had experienced an increase in the number of employee DSARs. So they're going up. There's no doubt about that. There's an increase in cost. They've not put stuff in place to deal with it. Additional staff are required and everything else that goes around that. So how can we simplify the process? Thanks, Rudy. Okay, how can we simplify the process? The key considerations that we should be looking at. Be aware of the context of the nature of the data that you hold before considering whether it's ready for release. Is it legal correspondence that need to be considered for release? Is it sensitive? Is it third party? Is it detrimental to the individual? But whenever you're putting these things together in your mind, be aware that just because you think it's sensitive doesn't mean it's not going to go. Just because it's third party data doesn't mean it's not going to be released. And the rules surrounding, the law surrounding health data is very strict on this matter. So if you've got that data, look at the context of why you've gathered that data, and that context will impact on how you release that data. So that's really important that we look at the context of why we've got the data and what it is that we're going to release. Thanks, Rudy. Okay, the subject access request then. The approach, I appreciate, of course, it's not always as simple or complex. But if we look at a simple request in simple terms, single location for data, no third parties included in the data. You might want to involve the DPO to validate disclosure. Have a think about it, but sometimes these things can be that simple that there's no requirement. I put a note on there about archived information because the ISO has said that archived information is currently subject to DSARs, and all the rights that a data subject has under Article 15 and beyond, between 12 and 20, then apply to archived data as well. Point to note on there that deleted data may be dealt with differently, but again, we'll cover that. Okay, complex access request, multiple information sources, where you're gathering information from HR, from OH, from IT, from the grievance team, masses of information coming in from different places. The release of contentious information. Again, we've got to look at what exemptions that we've got available to us there. Is it management forecast information? Is it information that impacts on other people? If you've got several requests from the same individual about different parts of the data, and it involves the release of third-party information, this is the time where you really need to think about getting the DPO involved, or even legal advice if need be, before you start looking at releasing stuff. Thanks, Trudy. Okay, third-party data then. Third-party data, there's a lot of misconception here about personal data. Just because somebody's name is on a document doesn't make it their personal data. We know that you've got to look at, again, the context of the name being on that data. If we've got third-party data contained in there, we can't release it unless we've covered one of the points that we need to look at. So, can we get their consent to release it? If we can, fine, not an issue. Do we have a duty of confidentiality to that third party? Be aware of whistleblowing, of witness statements and grievances. The rules concerning whistleblowing and statements in grievance procedures are different from normal release for third-party data. So look at that. This all goes back to our context of the data that we're holding. What steps have we taken to seek that consent? If we've got car parks and somebody wants their CCTV data of a car park incident and we don't know the other people involved, then how are we going to release that CCTV data? The advice that the ISO gives on that is to, if you cannot seek consent because you don't know who they are, then you should make stills. If your CCTV data, can't redact people, blank their faces or whatever, then you should take stills and redact the faces of the people on there. So whether the third party is capable of giving consent and any express refusal of consent. So if somebody says, no, I'm not going to, then we've got to weigh up the consequences of releasing that data and the rights and freedoms of the data subject against the person that doesn't want their data released. And you should also disclose any to the subject that information was withheld and why, but not in every case. There may be cases where you're not going to disclose that you've withheld information. And I'm particularly thinking about here where you've got an investigation ongoing. A bank is investigating a fraud, and to release any information held would show that they were investigating the fraud. It could well be a member of staff that's under investigation, and then you may, and I emphasize on all of these, you may have a reason for withholding that information. Okay, thanks, Rudy. Okay, so the subject access then, the stages that we've got within here. We've got 5 stages. Thanks, Rudy. Okay, step 1, recognize a DSAR. Goes back again right to the very beginning. Is this a subject access request? If you're part of an educational authority, a school, and somebody says, I want to see my son's school report, that's business as usual. That's not a subject access request. There, the school or the educational authority has got 15 days to respond. So you need to recognize whether it's a SAR or not. Stage 2, validate the request. Validate and request the proof of ID. Keep it proportionate. I dealt with an organization once that they said they were quite happy to take subject access requests and deal with them in a timely manner as long as proof of identity in the form of a passport was taken to their London office. That was the only office they had, was in London, and they were a worldwide organization. This was in the first meeting that I had with the company, doing a gap analysis for them, and I think by the time I'd left the building, the policy had changed. You've got to keep it proportionate. You don't need a full biographic profile of somebody if the only information you've got is quite simple, comes under a simple request, and you're quite happy with their identification. Okay, step 3 then. Okay, handle a request made on behalf of third parties and children. Have a look at that. What is it that you're going to do? Is it going to impact on the child? How old is the child that the request is made about? Are they old enough to make their own decision as to whether they want their data released? Do they have the mental capacity to say whether they want? What is the parent and guardian relationship with that child? Just because it's a parent doesn't mean that you're going to release the data. Look at the third party data. What third party are you going to withhold? What third party data can you withhold? Okay, step 4. Okay, remove any third party data if you've got the rationale to remove the data. So this is at the redaction stage now. Remove any other data that may be exempt from disclosure, and we'll cover the main exemptions later, but be aware that it's at this stage that you're going through it, that you're looking at third-party data, you're looking at your exemption data. What I always say to clients, and the adage that I always used when dealing with DSARs, whether it's in this team or in former roles, is that you set out with the intention that you are going to release all of the data. And then you come back from that and say, what can't I release? Not a case of what can I release? You're going to release everything, and then you're going to come back from that and say, what can't I release and why can't I release it? And then do your own test. Do your own acid test. Can I release this? Can't I release it? Once you've done that, you'll reach at the next stage. The next step. Okay, maintain a record of what it is that you're doing. If you get to this stage and you realize that it's excessive, manifestly unfounded, etc., then you need to have a good record as to why you've reached that decision. You need to make a decision as to what exemptions you're applying, how you're applying them, and what it is that you need to apply, and your rationale for applying them. So that's the stages that we've got there. Helen, would you add anything to that?
No, I think, as you say, it's release all, review what you've got once the searches have been undertaken, and then make your decision in a sort of a case by case basis. So don't do blanket exemptions on any of the material, and it would be a good idea to just get a second pair of eyes so that you are not missing, because we all know, looking through masses of documentation, sometimes you can go a little word blind, and it's always to get a second review and just be absolutely satisfied that yes, that is what you're going to release, and that your justification for your exemptions, it is all noted, you've got a clear audit trail. Because once it's released, you do not know whether the data subject is likely to is expecting more than what you've sent, and therefore disappointed, and will go to the ICO. And it's then when you get the ICO's letter that you will be then reviewing and then going and seeing whether you've missed anything, and hopefully you haven't released something that you shouldn't.
Thanks, Helen. Okay, thanks, Trudy. Okay, what are the practical steps to managing DSARs in compliance with the GDPR? Excuse me. Thanks, Trudy. Okay, the practical steps then that we're going to take here. What does it all mean in practice? It's about governance. The main part of what we're talking about, if we've got the right processes and policies in place, then that will help us to do what we need to do with the DSARs, to answer them in a timely manner with the right amount of data going out. So we can see in there, embed effective data governance practices. There's nothing worse than going to an organization when we've assisted organizations, they've done the searches and they've said, yep, we've got 125,000 emails because this person's been with us for 18 years and we've saved all their emails just in case they needed them. If you've got a retention policy, which you should have, of course, make sure it's applied, not just a policy, that it's applied as well. Because if you've got the right data governance in practice for retention, that will mean the amount of data that you've got to search through and release is going to be proportionate to what you hold. Formulate policies and procedures for handling requests. Make sure again that everybody knows who to go to if they receive a request. How is it dealt with? Who's going to deal with it? Is it going to fall between two gaps? If it all rests on one person and that one person's on leave, who picks it up? So have the backup for that. Make sure you've got the policies and procedures and that they actually happen, that it's not just a paper exercise. Have a clear record. Know what it is that you've got. Data flow mapping. Know where your data is. Evaluate the data. Accurate and maintained. These are the principles of data privacy. Make sure you're only holding accurate records and they're up to date. Reduce the amount of personal data hold. As I say, don't hold data just because, just in case. Hold what you need, what you're legally required to hold, and what you legally can hold in compliance with your lawful basis. Make sure the data, personal data, is erased if it's no longer used, that it's deleted fully. Ensure staff understand what their roles are when handling a DSAR, so that everybody's not pulling against each other. Create template responses, not blanket responses. We're not talking about blanket responses. We're talking about maintaining a templates so that we've got them there. We're not reinventing the wheel every time that we write a letter. Ensure your DPO is kept informed. If you've got a DPO, if you require a DPO, make sure that they know what's going on at each stage, and keep a central log of all your DSARs. Goes back again to what Helen was saying. We're preparing, if you will, for the next stage. So when the ISO comes in and says, why have you done this? You've got a log there to say, this is why we've done it. This is what we've done. Thanks, Trudy. Okay, record the timeline and details. Again, I know there's a couple of people on the webinar that have worked with me before, and they'll understand that I'm normally of the opinion that if the answer is a spreadsheet, you're probably asking the wrong question. Well, a spreadsheet could be your friend here, because this is what you need to maintain on your DSARs: when it was received, the details of the request, confirmation of identification, any exemptions applied, when you finish the DSAR, issues or concerns that you had, justify retention period for the DSAR. This is the other thing. Sometimes accompanying a DSAR will, from a disgruntled customer normally, will be something along the lines of, I want all my data that you've received on me, that you've processed about me, and then delete all my data. Well, the two are counterintuitive, aren't they, really? Because you've got to hold that data in case there's a further complaint or the ICO gets involved. So make a note, keep that data away, put it where nobody else can see it. You might want to do that, but you then go back to the applicant, to the requester, and say, we're going to hold that data for 6 months, or until everything's happy, with the ICO is happy, and we're not going to have to go back into it again. This happens an awful lot, certainly with disgruntled customers, where they want to know, they want you to get rid of the data as well. Thanks, Trudy. Okay, I've put this down as the commonly applied exemptions, and I've put in no particular order. And the reason I put that is that even again, 6 years on since the introduction of GDPR, you talk about lawful basis, and because consent is at the top of the list, people think consent is the best thing for the best lawful basis for data processing. That's why I put these in no particular order. Unfounded, excessive, or malicious. We've discussed that briefly. This is a reason for not doing a DSAR. If it's unfounded, if the applicant says, look, I'm going to do this DSAR, but if you give me some kind of benefit or whatever, I'll withdraw the DSAR, then that's an unfounded request. That's not the data subject looking at why you're processing the data. Safeguard third-party data. This is the most common one that we use in all DSARs that we deal with, and we deal with an awful lot per year. The protection of third-party data, and it's so important that you don't just do a name search when you're exempting third-party data, because of course anything that's a describer that identifies that person as an individual can be construed and should be construed as third-party data. Negotiations with a requester. If you are in negotiations about redundancy or packages or anything like that, then you've got an exemption there. And again, this is one that we use a lot with disgruntled either ex-employees or serving employees. Crime prevention. And we're not talking here about crime prevention authorities, the police, etc. We're talking about, as we said earlier, if you're investigating a fraud. or you're investigating a theft on site, then you might not release the data of the person putting their fingers in the till, because that's the investigation that you're dealing with. LPP, legal professional privilege, and I've highlighted Scotland in there because in Scotland there are parts of the Confidentiality Act that impact on there as well. And bearing in mind when you're looking at legal professional privileges that there are two levels to that, about how we should apply legal professional privilege and when we shouldn't apply legal professional privilege. Helen, are you happy to expand on that?
Yeah. Legal professional privilege, as John said, is two parts. First is advice given by the legal professional, and second part is in contemplation of litigation. So when you're looking at the data, you need to ensure, if you're going to look at LPP as an exemption, on what basis you're applying. Is it to do with litigation, or is it to do with advice given by the lawyer to? It could be, so let's say a disgruntled employee and you've outsourced to get legal advice on maybe a settlement, then you would go to the part one of the legal professional privilege. You wouldn't just do a carte blanche. So be very aware of that. Because again, should the data subject not be happy with your exemptions, they can go and will go to the ICO, and the ICO will look at how you've applied those exemptions and will actually ask you to justify those exemptions. And especially in LPP, I have seen where they have taken lawyers to task about applying an exemption on, say, advice, where in fact it wasn't an advice, it wasn't privileged on the basis you, as the person buying that service from the lawyer, you are receiving that advice, and they've just actually redacted it as a blanket one. One thing I wanted to add with regard to, say, negotiations with the requester, so that could be in contemplation for redundancy or moving offices. We have seen that at the time the data subject received an exemption on negotiations, and then considered maybe 10 months later those negotiations they have ceased, and then tried to submitted another request, thinking the exemption has then lifted. It's down to yourself. If those negotiations are still ongoing, then you can still rely. But obviously, if those negotiations have ceased and they've submitted a new request, then you may not be able to rely on that exemption. So it is mindful about how you apply the exemptions, and looking at one stage, is there a possibility that those exemptions, if a request came down the line, say 6 months later, you may not be able to rely upon them.
Thanks, Helen. Good points there. And I think it's interesting that although the ICO is, as we all know, snowed under and behind on work, then certainly we've seen a case recently where the ICO has come back to a law firm and said, justify your exemptions, show us what exemptions you've used, you've got 7 days to do so. This is why whenever we deal with the DSAR and GRCI law, that we annotate every exemption that we use, because we're looking at the next stage of the DSAR process. Okay, thanks, Trudy. Okay, let's look at a scenario-based incident then. Director for a medium-sized retail outlet receive a request from a former employee via solicitor coming in from a third party for all emails, etc., that mention her by name, initials, or pay number since she joined the company in 2018. And you can see what else is on there. Interesting points there: a copy of a grievance file and a copy of her HR file. Let's have a quick look at those, because we're sort of going on a bit for time, sorry. The ICO is very aware that a lot of applicants, requesters, have got into the habit of, my name is John Potts, I worked with the company for 5 years. I was called John by some people, Potts by others. Some people spell my name with an H, some people without. Some people put one T, some people put two T's. I was known as Potsy. Some people refer to me as JWP. Therefore, you will search on all of those separate guides or whatever. The ISO is conscious of that, and the ISO's response is, no, you don't have to search on those laid down by the requester. You just have to make sure that the requester has got all the information that they are entitled to. You don't have to submit each search using the initials. If Terry Henry submitted a request to Arsenal, I suspect they're not going to search for the letters TE in everything that they've ever had with his name on it. So be aware of that. So copy of a grievance file, we'll talk about that later. Okay, thanks Trudy. Okay, so the requested data today, the applicant was recently dismissed for overcharging customers at the point of sale. You're aware that she's already started proceedings for wrongful dismissal, already dealing with your own legal counsel regarding the impending employment tribunal. Her grievance was not upheld. Considerations then. Valid request, certainly sounds like it. Identity verified, keep it proportionate. If this is the email address that this person has been using with you for the time that she's been employed, then that may be enough. You may want to further check that because the amount of information that's on there with other information that you hold, but keep it proportionate. Fishing to obtain information for an ET doesn't matter. Doesn't matter why she's looking for this. As we know, or we should know, or you will know by now, that subject access requests are purpose or reason blind. That's why we say if she's asking for a grievance file, she's quite entitled to that grievance file. Go back to what we said earlier on about whistleblowers and statements. They may be treated differently, but in the main, everything's in there. Excessive, we can have a look how much data there's going to be and what's our completion date. Let's keep an eye on that because we need to look at how much data is coming in, how much data we're collecting, what work has got to be done. Because remember, if we're going to apply an extension, and we're not applying for an extension, we are applying an extension, i.e. because there's a vast amount of data or whatever we need to do, seek advice, which we're going to justify, we need to get that to the applicant, to the requester within our first month. Thanks, Trudy. Okay, our immediate actions then. We're going to log the request and start the timeline. We're going to acknowledge the request, bearing in mind what we said earlier about making sure that we are happy that we are releasing the acknowledgement to say that we hold all of that data or we hold some data to the right person. Consider putting a hold on deletion of files, etc. If you've got an automatic deletion policy, consider putting a hold on that so that you're not going to have files deleted in the time that you're dealing, whilst you're dealing with a request. The thing that I would add to that, and this should be part of your policy, that people need to be aware that it's an individual criminal offence to delete DSAR personal data when they know a DSAR has been submitted. Goes back to your template letters that we spoke about, having the template letters ready. Have a section on there that says, if we write out to individuals within a company, a template letter reminds people of that requirement. You can soften it by saying that this is legalese, but you should be aware that it's an individual offence to delete personal data once you know a DSAR has been submitted. Start the searches, utilize IT. You know, anybody who uses 365 will be well aware that the wonderful thing about 365 is it's got an incredible search facility. The really bad thing about 365 is that it's got an incredible search facility. It will bring back massive amount of data. So it's important that you know what it is that you're looking for and you advise IT the same. Contact HR, read the grievance and HR files. Yeah, let's look at those. It could be that they're going to be released in full, but think about the whistleblowing. Think about other people on there. If you're discussing somebody's HR, it could well be that within there, other people's situations have been discussed as well in that context. So look at the files, don't release them without looking at them. Identify third-party data, co-workers, ACAS. We know that there's an ET in place. Think about ACAS, because ACAS have their own rules. They don't override data protection laws, but they need to be looked at. Same as whistleblowing, the same as third-party statements, agreements, etc. So look at who else is involved. The initial search revealed 70,000 plus documents. Is that excessive? I would say the ICO will say no. Consider asking the applicant to narrow down her request. One of the reasons that we can stop the clock is we can ask for confirmation. So we can go back to the applicant and say, we've got 70,000 pieces of data. Are you looking for something specific? We can stop the clock until they respond. If they don't respond, then we can stop the clock and don't need to respond. Don't need to reply. If on the other hand they come back and say, no, I want everything, then we're back in play again. But you've made that request, if you will, to ask them to consider narrowing down. Consider extending the response period. As we've said, look at extension there. Software to deduplicate. Nightmare. One person sends an email, somebody forwards it on, somebody forwards it on there, somebody forwards it, somebody saves it, and you've got duplication and email chains. Again, the advantage of ourselves is that we've got deduplicating software that will find all the duplicates that we've got within the chains. Apply any exemptions, manually review all third-party data, apply exemptions, notate all of your redactions. Be ready for the next stage. Be ready for I want you to review this. The ICO wants you to look at this. The ICO coming back and saying, why have you redacted line 7 on page 9? Why have you done that? Make sure you've got those redactions there. Thanks, Tree. Okay, drawing it all together then. Check and check again that you've completed the request from the point of the requester. Look at it. Say, what is it that she wanted? Have I provided that? And if I haven't provided that, why haven't I provided it? I haven't provided it because it's LPP, legal professional privilege. I'm going to explain that data's been withheld on this because it's legal privilege. Prepare your covering letter. Provide secure access. The Act says that they should be provided with the data in a format that's readable and that's acceptable to them. If you can provide it through the post, through a registered system, fine. If the applicant is willing to accept that, we prefer at GRCI Law to use a secure share file. So once we're happy with the identity and the validity of the request, and we've completed it, then we'll send a link to a secure share file that the applicant can download. And then last of all, prepare your files for the ICO complaint, because I can tell you in this scenario, you're going to get an ICO complaint. So be ready for it. Make sure you've got your exemptions all sorted out. You know what you've done. You know why you've done it. Thanks, Trudy. Okay, finishing on a whatever note, and this is totally non-political, I can assure you, but this is the last reprimand. This is the last reprimand that the ICO issued on the 28th of August. So they're there. DSARs are out there. They're coming in all the time. The ICO is very, very alive to them. It's a way of people for checking their personal data, which is why it's there in the first place. We need to remember why it's there. So remands, we're probably not far off a fine being dropped down now. The ICO has issued a lot of reprimands, and I know that we have DPOs on LinkedIn and things like that have been complaining for a long time that the ICO is not throwing out enough fines. Well, don't be the one that gets fined. As I say to to data controllers, you don't want to be the case law. You don't want to be so-and-so versus your company on the case law. Okay. Thanks, everybody. Lord Honor.
Thank you, John, for sharing your great experience on that topic. We are almost coming to the end. So the data subject access requests in some instances are an indicator of issues with the business level of compliance. This may be, if we look at the case law, not only the UK case law, but also the European case law elements in regards to transparency, lack of clear procedures in how to handle data subject access requests, and more generally data subject rights in an effective manner. So it is also when a company receives a data subject access request an occasion to look at overall compliance level, what they have in place, the DPO role, need for EU-UK representative services, how they handle data breach, for example, and also how they handle contract or how they deal with due diligence. So those elements are services that GRCI law offer and can help the companies to reinforce the compliance. And here in this slide, you find a link where you can learn more about the offer of services we have here at GRCI law. Thank you, Trudy. Can you go to the other slide? So here in this slide, you have a summary of core activities that are included in the data subject access request services. So when we are engaged as an outsourced services to handle data subject access request, we will aim at managing basically all the process around the data subject access request, assess the nature and validity of the request, locate, help and advise on how to locate the relevant data, liaise with the relevant individuals at department, screen then the information, obtain third-party consent when it is necessary, and then apply the reductions and exceptions as necessary. Then also support with disclosing the information to the individual and help the business to document facts around the data subject access request. And of course, we liaise with the authorities, ICO in the UK and other supervisory authority elsewhere. As regards the particularity of our team, we have covered that earlier, considering the time that it remains, it is important, I think, to look at the questions we have had as well. And if you would like to have more information on data subject access requests, you can also download here in the link that you will have available with the slides, a PDF guidance on data subject access requests that I believe is useful. Next slide, Trudy. So yeah, so we are here at the questions section. There is one important remark that has been dropped in regards to the role of the data protection officer while handling the data subject access request. So I believe it is in regards to the steps or a previous slide. Where it has been mentioned that the DPO need to be involved. Of course, as rightly the attendees has underlined, the DPO doesn't consent or take any decision. So Article 37 of the GDPR regards the DPO, how it is appointed, and also we have further down in the GDPR the task of the DPO. So the DPO need to ensure that the regulation is implemented and also to ensure that policies and procedures of the companies are implemented in an effective manner. So the DPO need to be aware when a data subject access request or any other data subject rights is lodged, and need to be able to advise. And so, for example, how the legislation is applied, how exemptions are applied, and therefore to be able to advise and give recommendation. Of course, the ultimate decision to release or not to release, how to respond to that subject access request, it stays with the accountable person in the business. So thank you for the comments, very pertinent. And also, I think there was other questions in regards to releasing documents. As a data subject, a right to obtain a full copy of documentation, as it is, for example, for the human resources file or any other file.
Yeah, I'll pick that up, Donna, just quickly, if I may. But we have to bear in mind that the requester is entitled to access to the data, not to the documents. So we don't have to release the document itself. They're entitled to the data. So we're not just going to photocopy the HR file, which is the example that we've used there. So bearing in mind that it's the data, not the document, that the requester is entitled to. And there was actual case law on that, and I'll make sure that we get that out to people that have asked for it. The other question I'll pick up on there just very quickly, if I may, is that are we really expected to review 30,000 emails? As I say, I suspect if you've done your search properly, you've not got 30,000 emails containing personal data. It's that initial search that is the issue, narrowing it down on there. Very quickly, and we'll put the case in there. I received a case once. I dealt with a case where an absolutely incredibly horrible man wanted all the data that the Met held on him on several horrendous crimes, and the ICO in the first instance ruled on his favour, and we ended up at the High Court getting a decision that it was excessive. And the reason that we said that was that I would have to employ 2 people full time for 6 months to complete the request, but the ICO took it to court. So each individual case has to be judged on its merits. Okay, I'm not sure we've got time for any more, but I think any more questions that we do have, as Loredana said at the beginning, we will put together and get them out to people that have asked them, or as a whole. Helen, just very quickly, is there anything you want to add? We've got about 2 minutes. Sorry.
I think there was one question that's just come in late, why a name in a list may not be considered personal data. The name itself is personal data, but if, say, for instance, you've got 20 Excel spreadsheets and the name is in 20 Excel spreadsheets, what you could do is put the person's name and actually just document the name of the document that name has actually been found. So the Christmas card list, Christmas bonus list, summer holidays. So we're not saying the name is not personal data, but a name in a list, you might not want to release 20 documents. You can actually just put the name and actually refer to the document that name has been in.
There we go. Okay. From me, thank you everybody for staying, for the questions that you've asked. We will get around to answering them, but some of the questions that are on there now that I can see, I think really warrant more than just a very quick answer. So we'll get the written answers to you.
Yeah, thank you everyone. So we can wrap up here, and for the question we will follow up, of course. And in regards to the question that relates to the DPO role, for your information, there will be some forthcoming webinars still this year and next year will be organized, where we will tackle also this aspect, and there are some other topics as well on the agenda. So stay tuned and contact us if you need. Thank you everyone.
Thank you.
Thank you.